Okay, guys, if you joined us, you are able to see some Q&A that may test exactly where you are in your knowledge and understanding of where a lot of legal tools can work to protect you or where there's some risk that may exist out there for you. And today we're talking about risk, particularly civil judgments, and how you can do your best to protect against them. Now, lots of people don't ever want to be sued, and many people feel like they live their lives so that they do not get sued, so they do not have this liability against them. But lots of ways that your life may be open. It may just be people being on your property. It may be you getting into a car accident, or your kids or family being in a car accident, or just as a business owner, a variety of things, ex-employee, client. There's lots of ways that you may be open to a lawsuit against you, even if you don't know it. And unfortunately, you can't win everything. And sometimes what you do not win is a lawsuit against you, in which case, if there is a monetary award at the end of that judgment, you may have a judgment against you, a civil judgment against you. And satisfying that judgment, meaning paying it, can feel very overwhelming, especially if you don't have the funds or if it will be a strain to you or your budget to provide the funds. So we're going to talk about smart ways that you can anticipate some of this. As they say, shit happens, right? Things happen in the world. You have to be able to understand how to navigate them and do so legally. So we're going to talk about doing it. It's not about hiding assets. It's about planning properly. And hopefully we can give you some tips on how to do so. If you didn't know, my name is Eleanor Curry. I am the managing member of the Curry Law Firm. We are a full service law firm, and we are a full stop legal shop when it comes to business and real estate. So if you have questions on your business, on your estate plan, on selling a business, on starting a business, we are here with answers. And clearly you can see from the picture, we are a women-led, but also a women-staffed firm. And we have all a plethora of experience, but really all real life experience in making sure that whatever plans you have for your business or your life, we can assist in bringing it to fruition from a legal basis. So we really pride ourselves on being partners with our clients and getting what they need done, and sometimes anticipating things they did not even see coming, such as judgments. So what does being judgment proof mean? This means that you have protected your assets or put your assets in places where a creditor could not do some automatic collections on you in case they win in court. So this is a way to ensure that certain assets are protected from legal strategies and from seizure, and putting strategies in place that are legal pursuant to the state laws. So it does not mean that there's no way someone could collect. If you have lots of assets, there are lots of ways that someone could potentially collect on you if there is a judgment against you. But you can be very smart with your assets, putting things in the right place and ensuring that someone can't reach over to a box that it does not apply to in order to satisfy a judgment. So if your personal things are in one place, that's one thing. If your assets for a business are in one place, that's another thing. And keeping those divisions help you become judgment proof. Now, that doesn't mean there are not some natural protections, and we'll later talk about what the state protects as far as your assets when it comes to a judgment. Now, why does it matter? If you lose and a judgment is against you, certainly they have a right, or someone's interested in trying to collect. If they were awarded monetary damages, they don't want that just to be a piece of paper. They want to know how they can get it from a damage or award with the court to cash in their bank, or cash in hand, or assets in hand. So they have an interest the same way you would if you want a judgment and you may be the one wondering how to get assets from this person, what's applicable and what is not. So creditors do have a right in certainly lots of instances to pursue your bank account, to pursue your property, to pursue certain assets. And these judgments can last for years. Once a judgment lien is filed, it is on the record for 10 years and it can be renewed. So it may not feel like a big problem now. I just don't have it. You can't get something from someone who does not have it. That is true. But in the next decade, you may have it, in which case that judgment may be collectible. So don't just be very short-sighted thinking that someone can't reach you just because you don't have it now. You may have it later, and that may be fair game. And you want that protection. You're building something for your family, for your legacy, for your business, and you want to make sure that you've done your due diligence in making sure it is protected and stays protected. So let's just talk about what people commonly say to me. I don't need protection because I don't have it. I don't have a lot. So what am I protecting them for? But sometimes it's particularly when you don't have a lot and then you have your bank account seized and now your whole world is in disarray, right? Because you didn't have the information, you didn't pay attention, and now you say, well, I don't have it, or I don't have enough to satisfy it, so I'm not going to make the attempts. And now someone has a lien on your bank account, your mortgage payments are getting denied, your accounts have been frozen. That feels probably worse if you don't have a lot of money than it does when you have, when you don't have a lot. It feels horrible. When you do have a lot, it may be an inconvenience, but nobody likes their money being taken from them without anticipating it, and that certainly can happen if you have a judgment against you. Second myth that I'm going to be talking to you about how to hide money. No, that's not legal. You can't have the intent to keep money away from someone. This is about smart planning, and smart planning usually happens when you don't have a big disaster at hand, right? So we're not planning, hey, here you have a judgment against you, here's where to hide all your money. I don't want to be a part of that. And you shouldn't be a part of that either. It's about smart ways that you're segregating your money. So you are only, somebody's trying to collect on areas that they have a right to collect on. They're not just trying to seize your entire life. Last but not least, I'll deal with it when I get sued. And I think this is just like the procrastination model. I don't want to deal with it. I don't want to talk about it. The best opportunity you have to defend yourself is in a lawsuit. It is very difficult, or it's a lot more work to reverse a lawsuit. So if you have a preliminary view of some trouble coming down the line, or you are dead smack in it, pay attention to it, do what you can where you are. That may be you representing yourself pro se, that may be making efforts to the debtor or to opposing counsel, but do what you can, and at least you can give yourself a pat on the back for doing the best you can if you find yourself in any of these situations. So let's talk about what the state of Texas already protects. If you are in a different jurisdiction, check with your state. There may be protections, but there may not. Texas offers a wide range of protections, but not every state does that, and you don't want to go in here blindly. For Texas, for real property, they do protect your homestead exempted property, so that you have properly filed with the county clerk, that are the tax assessor's office, that this is your homestead, you have met the qualifications for homestead, living in it at least half a year. And so if you have done all those things, that property is protected from collection from like a civil judgment lien. This is not me saying that the IRS cannot reach it, or in different property taxes cannot reach it, but this is for a judgment lien creditor. Yes, your homestead is protected. Your other properties, in addition to your homestead, are not protected. So investment property, second homes, no, those are not protected. Retirement accounts, 401ks, IRAs are typically protected. If you're doing some type of rollover to your personal account, then you can't just have that lingering protection. So be aware if you're doing a rollover that it may become fair game. Life insurance policies and annuities are certainly protected, and that includes cash value or monthly payouts or quarterly payouts you may get from them. Social Security benefits are also protected. Real property is protected to a point. That's furniture, clothing, things in your home. They are protected up until $50,000 for an individual and $100,000 for a family. So you have some natural protections given to you by the great state of Texas. Make sure you're aware of them. And if someone's trying to collect on things that are in these boxes, that you exercise your right to say you can't collect from those arenas. Now, wages and income. This, again, is just for civil judgment. They are not typically allowed to garnish your wages. So to send an order to your employer to say, even before he gets any of his funds, you're going to write a check to me or split his proceeds with me. That is not true for different types of judgments against you, such as a child support judgment, but it's typically true for a civil judgment against you. Because, again, Texas has strong protections from garnishment. So they don't want just anyone being able to come and say, this person owes me, without it going through the proper channels. And it arises some employer liability, which they want to stay away from. And also disability, veteran benefits are also exempt from collection. Now, When we come from it from a business perspective, lots of times you set up your business because you do want these protections. So this does not apply to a sole proprietorship, and that is the type of business that is essentially you. Even though you have a DBA, if I had a Curry Law Firm DBA, although it has its own separate name and it does have a filing with the state, it is not considered a separate entity. It uses my social security number. When it files taxes, it is me. So a sole proprietor is you, but you do an LLC, a corporation, an LLP, an LP, because you do want some additional protections and you want it separated from who you are personally. So sole proprietorship, you are the business, which means your personal and business liabilities are the same. And LLC is considered a box where the assets of that box are considered the extent of your liability with certain exceptions. And then a corporation, there's more formality, but you do get the same protection or similar protection to an LLC, meaning the assets and liabilities of this entity are the entities alone and are not yours personally. So when you sign strong contracts indicating that the business is a part of the contract as opposed to you personally, and you are only signing in your role in that business. I'm the owner, I'm the manager, I am the president. If you're signing in that capacity, and you can do a simple check, look at your contracts. If it says the business name, and when it says any parties to the contract, and it has your name, because you do have to sign as your person, and your role, then you typically do have a contract with the business as opposed to you personally. Now, I love LLCs because of the flexibility of the whole thing. You can use them for a variety of ventures and assets. You can go into a partnership with an LLC. You can combine forces with friends or family members to get things done with the LLC. Even something like a series LLC can have different levels of structure where you have one level of protection, just kind of thinking of it as a holding company, and these different businesses that work within the holding company. Now, where you can get some liability that seeps over to your personal life and your personal assets is when you sign as a guarantor. The LLC, it becomes like two different contracts: a contract with the LLC, which they can choose to try to collect upon, or the guarantee of payment with you, which becomes its own contract and they can collect on together or separate. So they could say, fine, your business doesn't have any money, but look, you have a bunch of money. You signed this guarantee and we want our repayment from that. So let's talk often, and this is pulling from just what people commonly ask me when they call in for a consultation. Hey, I want to make sure nobody can get this. This is usually how the conversation is housed. So often they say, I want to put things in a trust because I don't want anybody to ever get it. I want it to be for my kids, for my family, for whatever purpose. So just so you know that there are lots of different types of trusts, but today we'll just talk about two of the most commonly used: revocable and irrevocable. A revocable trust, it provides some structure, it avoids probate, it lets people know who is in charge of certain things, of your children, of your assets, of distributions. So it is a great tool for planning and for, especially if a worst case scenario happens, you're incapacitated or dead. However, in your lifetime, because you get all this flexibility, you can move things in and out, you're completely in control. What you lose in that is being able to say your assets are completely protected. Essentially, it's considered you still own the assets, even though they're housed under this trust. You still file taxes under your social security number. It is, for most part, considered an extension of you. So it gives you lots of really good things, but complete asset protection is not one of them. Creditors and litigants can still asset any of the assets in your revocable trust during your lifetime. And it is only considered, this next one, irrevocable at the time of your death, meaning it cannot be changed and it is no longer under your control. So irrevocable trust is a permanent giving. You get that protection because not only are you giving away the actual asset, and it is only considered proper transfer if it's for the benefit of the beneficiaries, but you are also giving away control. You both do not control the asset, and you no longer own it. It gets its own EIN number, it becomes its own entity, and all the transactions have to be for the benefit of someone. So you can't say, well, I have this business, I put in irrevocable trust, and I want to get $100,000 out to me, and I'll sell the rest. certainly you can structure it a variety of ways, but by and by, that money for the sale from a transfer has to go back to something that benefits whoever you have written down as the people you care and are concerned about and want the trust to benefit. So it's not yours. And so in that sense, it's not yours. So creditors can't get any more. It's someone else's. Now, on the advanced side, you have just the natural protections that come from your personal structure, the protections that come from the state of Texas. It just says you can't reach these assets, less than $50,000, assets in an LLC, your homestead, natural protections. Then you have an extra level of protection in putting things in an LLC, because the things that belong in that box are only in that box unless you do something to open that box, like sign a personal guarantee. But you can combine trust and owner and LLCs for a different mix. And the intention is always, what do I need? And what is this particular component providing for me? Lots of people come to me with really advanced strategies that they've seen online, and the cost and the long-term upkeep of it, filing taxes, filing your renewal with the Secretary of State, may not be necessary for your particular level of protection. So for every stage, don't be afraid, ask questions. What is this particular stage doing for me? How does it benefit me? Yes, I'm separating control, ownership, and liability, but is it also giving me a bunch of formalities? I need a bank account for all of them. I need to be writing checks and sending invoices between my own companies, or who is the signing partner? Is it the trust? Is it the business? All of these things can be very confusing. And if you don't do it right, the consequence could be you lose the protections. So if you just throw all your money in one pot and say, well, I have a trust and an LLC, I'm protected. No, that's not enough. You have to act like it's all separate companies. So yes, step one is setting it up, but step two is transacting business or your personal affairs in these lines of operations. So that can be the part people forget. And often if you forget it, by the time somebody brings it up, it's too late. You've opened the door. So you keep the things, I call all these things in a box. You're keeping your LLC in a box. Your personal assets are in a box. Your trust assets may be in a box. But if you open the box, then it can become open territory. So here we go, a box, a basket. I say a box because we're putting assets in something, but the goal is to close the box, and you only open and close it as items are fit. So a basket, somebody can reach in and grab things from a basket, but a box, hopefully you put a lid on it. So even with your basket, keep your baskets very far away from each other, and to have some processes when things move between baskets. This really allows you to separate your business assets, your business wealth from your personal wealth. So that can especially be real property. Lots of people start the real property journey and investing journey with just buying things in their personal name because that was the easiest way to get a loan or you got the best rate. And while that's a good start, it's important as you get further along in your journey that you take advantage of more advanced strategies. What worked for you when you own one property probably is not the best strategy when you own 10 or 20. You have to continue to elevate. You have to continue to grow. You have to continue to evolve what you're doing as a business owner. Don't just keep doing the same thing for 20 years and say, oh, well, it didn't hurt me, because often those are the clients who come very aggravated or frustrated that they're now in a $30,000 lawsuit and everything's on the table because they didn't take time to put some of these strategies in place. Like I said, it is a strategy. The strategy is not to run and hide. It is being intentional and on the offense, not on the defense, knowing that these things, lawsuits are a common risk. I think it's 1 out of 8 or 1 out of 5 business owners will be sued in the course of their operations. So it's not just a mystery of what it could happen. It's a likelihood that it will happen, and you can prepare properly for it and operate in the sense that things are separated, things are protected. So you may use one of these strategies. LLC may be a good fit for you right now. In 10 years, you may have a more complicated, I won't say complicated, sophisticated strategy based on your need at that time. So don't be afraid to level up. Do not be afraid to continue to learn and grow. And don't be afraid to look at what you have with new eyes. Often, you say, all I have is this and that. And then when I'm looking at it, I'm like, yeah, you have that house, but the house has $200,000 worth of equity. You have that business that you started with $500. And although you only pay yourself $1,000, it's $1 million business. All these are assets. And someone, a sophisticated someone, may be able to figure out a way to access those assets. So if you're not in Texas and watching this, your exemptions for your homestead vary per state. Some are very loose, some are very stringent, and that also may be applicable to equity. So some may say, well, we're not going to let them take your home, but they may be able to do other things like put a lien on your home, or if you have $1 million, $2 million, we're not going to let you sit on that $2 million while you owe somebody $4 million, right? Also be mindful of rental income. As I mentioned, lots of people start where you get your first home and you graduate to your next home, but you don't sell it. You keep it in your name because the interest rate is good or you're halfway paid out. You make it a rental property. But if you don't transfer it to something that does provide asset protection, it indeed may be at risk, and it is considered a second home, even if you don't live there anymore, even if you used to live there, or it was your previous homestead exemption. That homestead exemption is offered for one property. So if you're just kind of muddling all the properties together, or you have one property in Dallas and one property in Houston, and you say, well, I lived in both at one time, or I right now switch between homes. Only one for the state of Texas is extended a homestead exemption. So don't make the mistake of thinking that you have separate or dual protection. Land trust can be a separate layer where you're really separating the real property, which is the land, versus the improvement, which is the home on the land. So that may be another way to protect different assets that you have. And then married couple have a different rights for ownership, including one that's called tenancy by the entirety. However, please note, when it comes to what the options are for a married couple, it needs to be denoted in your deed. So your deed can say, just like your warranty deed that gives you the property, it can say you guys as a married couple. It can define tenancy by the entirety in a variety of other ways. You own 50%, you own 20%, whatever it is. Although we commonly don't, you may not have seen that in deeds that you have reviewed. Those are all options, but it should be in your deed and recorded with the real property records. Insurance is a great way. Just like you're planning this, insurance is a way to prevent the worst thing from happening. The legal planning can operate in the same way. It may never happen, but in case it does, you have properly put yourself on the offense. It's a great position to be in. Insurance is part of that offensive line. If you are a professional, that malpractice insurance, again, helps extend protection to your personal property. If you are a homeowner, these are a lot of the ways that you get civil lawsuits against you. Hey, someone did something wrong to me professionally. Hey, I got into a car accident with you or your kids. Your house, the tree from your house fell on my car. These are often ways people get into lawsuits, right? And so insurance can be a great defense where it's accumulating funds or offering to do your legal fees or pay out any settlements against you, as opposed to you putting that in your budget and planning, or someone attacking your savings account, for instance. So it can very well align with your legal strategy. But again, there needs to be strategy for both. We're not evading, we are just planning, and those plans can be perfectly legal. Worst case scenario, bankruptcy is always an option. It allows you to discharge some debts. There are different kinds of bankruptcy, 7, 11, 13. I won't get too much into details about it, but don't just assume that bankruptcy is either hard or easy or embarrassing. It is part of a legal protection. Lots of people use it. Lots of very rich people use it. Our president has used it many times. So it is a legal protection there for you. You have to understand the nuances, and most importantly, understand there's a cost. I worked with a bankruptcy attorney previously in my past, and to start the process was $5,000. So it does not mean you're broke all the time. It means that you're taking steps to realign your financial responsibility, or that you just owe more than you have, but that doesn't mean you have nothing. So be aware that there is cost to bankruptcy, and different types of bankruptcy can get different results. Some types of bankruptcy are just a complete wipe of anything you own, but typically those are not afforded to people who own real property. And then you have other types of bankruptcy that are more of a realignment. However, the sacrifice may be high because you're completely dedicating all of your funds to that trustee and to that bankruptcy effort. So just be aware that they are there. Do not be ashamed, but be knowledgeable about what those options are. So common mistakes: waiting too late, offense, offense, offense. Like any of the Texans fans are screaming offense. These are not defensive strategies. If you're in it, it may be too late because your intention is not to hide funds, is to plan well for your life. Once you get to the point where you're trying to hide funds or move money, that is a different intent, and you can be liable if you have bad intent. So make sure that this is a part of your strategy for how you plan. You do not want to mix everything all up and hope for the best. You don't want to, be one of those salad shakers and say, my tomatoes, my salad, my dressing, they're all in one container. No, things need to be in separate containers. Get very anal about this idea. It's your best way to have protection. Okay, DIY. I am not hating at this moment on some of the DIY, but if you don't understand it, you don't know how to use it, you're not following any process or procedure around it, even if it's supposed to help you, even if an LLC is meant to give you legal protection, if you don't use it the right way, you may not be applying or applicable for those protections. So make sure you understand it. Don't just do it because you heard it on the gram or you saw it on TikTok. Do it because you understand it and it's a good fit for your business, which usually requires you to at least talk to someone about the strategy before you run off and go do something and pay some fees, and then 10 years down the line it's not applicable. It did nothing for you. We don't want that. So yes, be value conscious, but the value is the benefit, not just saying you did it. And then if you fail as your life continues to grow and change, to update things, that can be a problem too. The more you got, the more sophisticated the strategies be. Get your accountant involved. Get your wealth strategy or investment strategist involved. Get your lawyer involved. Don't assume your problems at $10,000 will be your problems at $1 million. I assure you they will not. And that can leave you holding the short end of the stick if you don't plan properly. Again, last but not least, but an important reminder, we're not hiding. We're not hiding. We're putting things where they belong. We're utilizing the protections provided to us by law, and we're standing beside them, right? So if your things are in an LLC and somebody says, that's not fair, you make much money in your LLC, please note with your LLC, they may be able to reach your membership interest or let's say distributions from the LLC. So I don't want to make it sound like it's a complete protection, but you're going to use these things to your benefit as provided by law, right? And so the law does give you certain ways to judgment proof your life and protect yourself. Utilize those ways. If you don't utilize those ways, the court can't pierce the corporate veil, meaning saying you put this front on like you had a business and you had these separate boxes, but we looked into it. The reality was that is not true. So we're going to say everything is you. And if everything's you, everything can be responsible. So be careful for piercing the corporate veils via commingling, being underfunding your business, saying you have a business, but treating it just like it is who you are personally. Be aware of all those things and the law will be your friend. And you're not hiding, you're not evading, you're just operating in the confines of the law, which feels good. So how we can help, we do a variety of things. Like I said, we are a one-stop legal shop for business owners and entrepreneurs that may be looking at your assets and providing some strategy, that may be doing wealth planning and preservation. Hopefully what you're planning today is something that can last for generations in your family, changing the trajectory of where you are now. So if you're the first to do something, take that first with pride, go to the moon. That's what we want to help you do. And then of course, business structuring and litigation events. When you find yourself in that lawsuit that unfortunately you cannot avoid, hey, we're here to help and walk you through the process. So protect your wealth, protect your future. It's what we're all about. It's something I'm passionate about. So that's why we have these webinars, and we are really hopeful that we are giving you the information and education to set your life apart, not just today, but as you continue to grow and life continues to throw flowers at you or darts at you. We're here by your side through it all. So most things, good plans come with good results, come with good plans. This is no different. Judgment proofing comes with proactive planning. If you want to reach out, please, please, please do. You can check us out at theclfirm.com or Plan with Trust. If getting a trust is in your future, reach out to us over the phone. We're happy to help. We're happy to listen. And we're very happy to answer questions to make sure you're doing the best to protect. Thanks so much, guys.